out with some formalities in saying thank you very much for the invitation to join today, with particular thanks to Dr. Niti Shikhar for the invitation, the Graduate Insolvency Program of the Indian... I can hear some background noise, and I'll just ask you to mute your microphone if you're not talking. Perhaps everyone can just mute. I can see people muting now on my screen. Thank you for muting. It will just help with some background noise. Thank you very much. I'll just go back a step to say thank you very much. Can people now hear me?
Yes, sir. Yes, sir.
Now we can hear you, Ian.
Okay, good. Very good. Thank you for the text messages. I'm going to start again. So first of all, thank you very much indeed for having me on this extremely prestigious course. I want to give my particular thanks to Dr. Niti Shikhar for the invitation. The Graduate Insolvency Program of the Institute of Corporate Affairs is a renowned and prestigious course, and I have spoken to a number of academics and practitioners who have told me that not only is it rated very highly for the quality of instruction, but in fact the quality of the students who attend the course is also very high. So it is my great honor and privilege to be joining today for this session. And I also wanted to just speak directly to some of you students to say, I recognize the sacrifice that you are all making in joining a course of this nature. It is a difficult and demanding course. Well done to you for the sacrifice for yourself, and no doubt the knock-on effect of the sacrifice to your families. And it couldn't be a better time for you to be pursuing your career in global insolvency because of the backdrop of this terrible pandemic of COVID-19. I hope equally that you're all coping okay with the lockdown that I hear in India is very strict, and that I genuinely and sincerely hope that you and your families are healthy and safe at this time. I have practiced insolvency law for 21 years, and it has always been a fruitful area of intellectual debate and discussion, with new case law being developed every year. It has also been a good area of practice because I've never been short of work, and now more so than ever, you will find yourself dealing with tricky, intellectually challenging issues on a scale probably never seen before in human history. It's important to note that at one time, a third of the world's working population was thought to be in lockdown. The economic impacts of that will be greater than anything humanity has ever seen. It is believed that the next economic downturn will not be a recession. That is too small a word for it in terms of how the OECD and the IMF and the World Bank define a recession. It will be a depression. And the debate now, and I'm not going to make predictions, the debate now is whether or not this particular depression will be worse than the 1929 depression caused by the Wall Street crash. So insolvency practitioners, get ready. You will be called upon to be working very hard, and you will be very busy in the months to come. So just a little bit about me, so you understand the context in which I'm going to give this talk. I live in Hong Kong, but I practice no Hong Kong law. I only practice British Virgin Islands and Cayman Islands law here in Hong Kong. And there's a particular historical reason for that. And as many of you will know, Hong Kong was made a colony by the British in 1840, and in 1997, Hong Kong was handed back to the Chinese following a 100-year lease of parts of Hong Kong by China. And in the handover, although the handover took place in 1997, in the 10 years before that, there was a lot of planning called handover planning by businesses, corporates, and individuals to protect themselves against the possible effects of the handover. And that is where BVI and Cayman Islands companies came in, because it was thought in planning for the 1997 handover that, in fact, China may or may not comply with the obligations under the various treaties that applies. And of course, we can see now China has complied with the obligations to allow Hong Kong to remain as a separate place, what's called a special administrative region under the one country, two systems model, and Hong Kong has its own laws, the common law, as well as its own legislation that's very, very different to China. But in that run-up to the planning, people were concerned that the Chinese government may not comply with their obligations and that private property might be at risk. So there was a move to use BVI and Cayman companies to own and control assets that were located in Hong Kong. And a good example is real property. So very often people would put their apartments into the ownership by conveyance, by instrument of transfer, into a BVI company, for example, because it was felt that if there was to be any conflict with the new Chinese government after the handover, that the Chinese government would be less likely to interfere with foreign property rights or owners that were foreign. Equally, on the Hong Kong Stock Exchange, to this day, about 80% of the companies on the Hong Kong Stock Exchange are either Cayman Islands, BVI, or Bermuda incorporated companies. So Hong Kong companies are not particularly popular on the Hong Kong Stock Exchange. And that has the same historical reasons as I've described. And that means that the law that one applies to the raising of public capital on the stock exchange is a little bit of Hong Kong law because of the listing rules that applies, but very much it is to do with the foreign companies' laws, BVI, Cayman, or Bermuda, because of course it's those places of incorporation that govern the way in which the company behaves vis-a-vis its members and the director's duties. So the memorandum and articles of association, or the bylaws of a company, as they call it in Bermuda, govern the relationship between the members and the company and the members inter se. That's the pompous Latin expression for as between themselves. So those articles, those constitutional documents, very much governs how those companies behave. One further background historical point is that a state duty was in force in Hong Kong until 2003, and so many people wished to avoid paying a state duty, or what English lawyers would call inheritance tax, and they then spent a lot of energy and time ensuring that their property was divested into a trust, and those trusts tended to be BVI or Cayman Islands or Bermuda trusts as opposed to Hong Kong trusts. So that background is important because, as I describe in my little introduction that you received, although I live in Hong Kong, I will be talking about BVI and Cayman law because finance and capital is generally raised on the public stock exchange through BVI and Cayman companies, and even the private raising of capital very often involves BVI or Cayman companies because, of course, those companies are well known for being places where the law is clear and reliable if you are a creditor. So, for example, if you were to invest in China and you were to lend money as a creditor to a Chinese company, that loan would be governed by could be governed by Chinese law, and your remedies might be in the Chinese courts. But if you're a foreign lender, you probably want to be lending to a BVI or Cayman company, because essentially the law that applies in those places is familiar to those that are familiar with English law, and the courts there are good, and the final right of appeal from the BVI in Cayman will land you in the Privy Council in London. So you eventually have English judges reviewing those decisions. And people often say that, you know, global international finance is lubricated by the existence of BVI and Cayman companies, because those companies have, as I say, good and sensible laws for lenders. You, as a lender, know that you can have pledges, liens, mortgages, and charges. You can petition to wind up the company if it doesn't pay the debts, if the company is insolvent on a cash flow basis or on a balance sheet basis, etc., etc. And importantly, of course, in the BVI and Cayman, no tax is paid on the existence of having that legal infrastructure. Of course, you must pay your tax in your own home jurisdictions. So how has this all affected the actions taken in Hong Kong because of COVID-19, that complexity to having this combination of Hong Kong law on the one hand, but also the overlay of BVI, Cayman, Bermuda law on the financial front, makes things a little bit more interesting and nuanced than perhaps in a jurisdiction where you might be applying one form of law for all of your transactions for your borrowers and lenders' place of incorporation. Well, firstly, what measures have the Hong Kong government taken here? What has the government's response been? Well, the Hong Kong government has recognized that a global depression looms, and that includes rising unemployment, corporate and business failures, credit defaults, failing asset prices, market volatility, and financial system weaknesses. The government policies are aimed, therefore, at preventing insolvencies, supporting incomes for employees or enforced leave, or what in England they're calling furloughs, and protecting, supporting the viability of the financial system. So on the one hand, there are particular industries, travel, hotels, certain leisure sectors, shopping, retail, that are particularly susceptible because of the lockdown of travel and the cessation, the ceasing of human economic activity. And the government is concerned that if human activity stops for a period of 3 or 6 or 12 months, then when it returns, the return should be such that those companies don't go completely out of existence. They're not rendered insolvent, wound up and destroyed. There should be something remaining later for the period when there's a recovery. And the key question is, what will the recovery look like? So will the recovery be what's called a V-shaped recovery? So that's a recovery that is very fast, very aggressive, economic activity returns quickly, and the demand for those services that has completely stopped now, fallen off a cliff, suddenly comes back. So a great example would be the hotels in Hong Kong are extremely empty at the moment because there are no tourists from mainland China here. They simply can't travel here. Will there come a point, a linear point, a single date, when travel restrictions are reopened and all hotels will suddenly be very busy? That would be a V-shaped recovery. Other people say it's more likely to be a U-shaped recovery, because even if travel is lifted and people do come to the hotels, they won't all travel at the same time. They won't want to take the risks. There'll be a slow testing of the environment to see that from a health perspective it is safe to travel. There are skeptics then, economists and lawmakers, parts of the Legislative Assembly in Hong Kong, that say, you know what, we don't think there'll be a V-shaped or even a U-shaped recovery. We think it will be an L-shaped recovery. And that means that the low economic activity we have will remain for a very long time and climb only very slowly, like an L on a graph of economic growth that will take years and years to recover. So the Hong Kong government is trying to take measures not only for those businesses that are in deep, deep trouble so that they will exist at a time of recovery, but it's also trying to protect the financial system. And I'll start, therefore, on what the government is asking the banks to do, and that is through the Hong Kong Monetary Authority, which is the regulator for banks. So small and medium enterprises in Hong Kong are especially hard hit in these times. Retail, restaurants, hotels, shopping, all the rest of it. And the Hong Kong Monetary Authority has asked banks proactively to simply delay demanding repayments from their borrowers. So to volunteer simply to amend and extend the loan documentation to say, you were supposed to pay last week, but we'll give you a holiday for those repayments, for example, for 3 months. And that is thought to then allow a period of grace or holiday so that these businesses can survive. Now, what's the key problem for all of these businesses? Well, quite simply, it is cash flow. Cash flow is the crisis of our times. As an insolvency practitioner, you must understand cash flow. For every business in the world, cash has become king more than any time ever before. That's always the adage of insolvency practitioners, cash is king. But now that is more acute than ever. And a great bit of evidence to show that is look at the price of gold. The price of gold, in fact, has gone down. And normally the price of gold in a crisis goes up because people say there is a crisis, there's a recession, money markets, financial instruments are unsafe and unstable and volatile. We should invest our money in gold. But in this depression, people are not investing their money in gold, generally. They are instead hoarding cash. They are selling assets that are liquid in order to get cash back and holding cash as much as possible. Why? Well, that is because I'll give you an example, a real life example of a client of ours in China. Obviously, I cannot name the name. The client is a factory in China producing goods, and the factory in China is deeply concerned about the demand for its products and whether or not the purchasers of its products can actually pay for the products. But the Chinese company is very concerned to keep producing so that it can generate revenue. And the Chinese company is prioritizing, obviously, the raw materials to make the goods that they make in the factory, prioritizing the staff that work in that factory, and prioritizing those third-party contractors for freight and shipping so that its goods can be shipped to the United States for purchase. This Chinese company has been looking at all of its other trade creditors. So those non-essential trade creditors, this Chinese factory simply will not pay. And they have indicated to the trade creditors in a very proactive and constructive dialogue, and they've said, we can't pay you because you're not essential. In this time of crisis, there is not enough cash to be able to pay you, so we've had to triage or prioritize. And for us professionals, of course, a number of factories are saying, well, lawyers, accountants, auditors, IT providers, we're certainly not going to pay you first because you're not most important. You'll be put at the back of the queue. And that creates a knock-on effect for professional services firms, clearly then worried about their own cash flow. And that little example I've taught on other courses here in Hong Kong and actually spoken to many business people about. It's quite important to understand how everyone is prioritizing cash and simply failing to pay those trade creditors that are least important. And as part of that process, in order to save cash, people are making sure that they have at least a 13-week cash flow forecast updated every week so that they can estimate when they might run out completely of cash. They're looking for cash management tools, for example, trying to speak to creditors to delay and elongate payments that are owed, trying to negotiate payment deferrals with fixed costs, landlords, for example, bank interest rates, And you have to remember that at the moment, revenue is way down because of the crisis, but fixed costs remain the same. And that is the cause, essentially, of the cash flow crisis. You still have the hemorrhaging of cash to pay fixed costs, rent, wages, etc., but you don't have the revenue coming in. And that's really where the problem lies in COVID-19, and it's more acute than any other time in history. Clearly, also business people are looking for government incentive, tax holidays, break their banks, etc. And the Hong Kong government, through the Monetary Authority, has introduced a number of other measures to the ones that I told you about, asking banks to introduce relief measures for the import and export sector in particular, extending repayment periods of trade finance facilities so that trade finance facilities are aligned with the longer, prolonged trade cycle that has arisen because of the COVID-19 outbreak. Equally, the government is asking banks to allow their customers to convert existing trade finance lending into essentially temporary overdraft facilities. And normally that's an absolute no-no, because when banks lend for trade finance, they have a good understanding of what the money will be used for, and they have good security because they know that it's a line of credit aimed at a particular bridging, if you like, of when the goods are bought and sold. But to use it for a general overdraft is a much riskier type of loan, which normally has high interest rates. So this conversion is quite a thing for the banks to do, again, all driven by the Hong Kong government. I should just say that Hong Kong has been in various forms of lockdown and emergency as early as the 25th of January 2020. So I know in India that you're all suffering terribly with the lockdown, and I hope you and your families are healthy and safe. But Hong Kong, in fact, declared an emergency very early on and introduced the lockdown, which means that the financial measures that they put in place also happened very early on as well. So as early as the 26th of February 2020, the Financial Secretary of Hong Kong introduced a budget that gave special low-interest loans to small to medium-sized enterprises. The loans were made by the bank, but the government gave 100% guarantee to those loans. Now that's very interesting, because some of you may have seen in the paper this week the British press criticising the British government because the British government were prepared only to guarantee, to underwrite banks' loans by 80%. Now, what's the problem with that? Because it sounds great. Oh, the government's backing 80%. The bank is only taking 20% of the risk. Surely the banks will lend money to the market generously to get us out of this crisis. No, because critically, the analysis for the banks, if they have 20% of the risk of the loan or 100% of the risk of the loan, is exactly the same. They have to take in the same due diligence, look at the risk of the loan going to default, exactly the same. So it meant that the banks simply weren't lending. And by Wednesday, I think, or Tuesday of this week, the British government changed its mind and said, we, the British government, will underwrite 100% of the loan so that the bank no longer has to take those same risk assessments in providing the credit. And intellectually, and perhaps with a bit of hindsight, it all seems obvious now, but I'm sure at the time of the initial financial package by the British government, it wasn't as obvious. But Hong Kong went straight away in February to 100%. And that's going to be very interesting when you as students look at other jurisdictions. You should definitely look at the level of guarantee percentage-wise for what governments are doing. So under this particular government scheme, you can only get 2 million Hong Kong dollars, which is about 230,000 US dollars. The repayment period is 3 years, and the government is giving a total guarantee amount of 20 billion Hong Kong dollars, so about 200 million US, and that's under what's called a concessionary loan scheme. Now, equally, the Hong Kong Monetary Authority, together with Hong Kong's insurance fund, has implemented other measures to increase liquidity in the banking sector. So remember, the banks can't loan if they don't have money, liquid money, assets to do so. And after the 2008-2009 financial crisis, the world put banks under enormous pressure to never allow a banking crisis to happen again. Governments around the world said we will not be rescuing banks again, whereby banks have, it was said, irresponsibly lent money out to borrowers who could not pay. And that was the basis for the subprime mortgage crisis in 2008 in the US, that a number of banks, through credit derivative swaps, were packaging bad mortgage loans, bad borrowing out to each other, probably constructively knowing, or should have known, that they were never going to be repaid. And that essentially caused the banking system to collapse. So since 2008 to now, those banks have been under enormous pressure. The world's banks have been under enormous pressure to be properly capitalized, to ensure that they have good cash reserves and not to lend recklessly either. And that has come in a number of global forms, international treaties. I'm sure some of you are very familiar with a treaty called Basel III, which was all about capital adequacy for banks. Now, interestingly, in Hong Kong, the Hong Kong government has quite sensibly, I believe, sought to increase the liquidity of banks so that they can lend at this very difficult time to support local economic activity. So the Hong Kong Monetary Authority has or will reduce the current level of the regulatory reserves required, i.e. that part of a bank's retained earnings that are earmarked, delineated for the purposes of maintaining adequate provision for possible credit losses, by 50%. Now that is huge, and will, it is estimated, release a further 200 billion of lending capacity into the Hong Kong economy. That's about 220 million US dollars. Further policy is for banks to offer extensions of loan tenor or principal repayment holidays to qualified small to medium size enterprises. So in addition, with this idea of increasing liquidity to make sure banks actually lend, because it's all very well the government saying, please banks, lend to these businesses that are suffering, but if the banks don't have, from a regulatory perspective, the ability to lend out that money, it won't happen. So the Hong Kong Monetary Authority has also lowered what's called the capital buffer ratio, which again just allows more of the bank's cash to be used. Equally, the banks are allowed to defer the implementation of this international treaty I mentioned earlier of Basel III, so that the capital adequacy requirements are not quite as strict. And finally, the Hong Kong Monetary Authority is allowing certain authorized institutions, certain banks, to temporarily lower their level of liquidity ratios, and in particular they will be allowed to monetize or sell some of their high quality liquid assets to bring more cash into the bank, in other words, under certain controlled circumstances. So that is pretty aggressive in terms of the government's action to increase liquidity in the market. But this has to be seen in the context, and this is why I mentioned it earlier, of Hong Kong actually having been, quite aware of COVID-19, because it started in China, it's very close to us here, since early January. And equally, you will have all seen in the news the protests and demonstrations that were affecting the streets of Hong Kong over many months in 2019. And because of that, Hong Kong actually slid into its first economic recession in 10 years in 2019. So a recession was already coming. And that is a combination of the Hong Kong protests, the probably the credit bubble globally, the overheating of the global economy, particular issues of probably too much credit in China, and then the US-China trade war. So put all together, there's been a recession in Hong Kong for a while, and the COVID-19 has compounded or accelerated the likelihood of this recession turning into a depression that's actually quite deep. Now, I promised to then talk about how, in particular, in Hong Kong, the BVI and Cayman laws will affect companies. And because 80% of the companies listed on the Hong Kong Stock Exchange are either BVI, Cayman, or Bermuda, because much of the international finance provided in this city is using BVI, Cayman, or Bermuda companies, and therefore that law applies, the director's duties that applies to insolvent companies, or any company in fact, but particularly when they're insolvent, is not that of Hong Kong law. Very often they are BVI, Cayman Islands, or Bermuda directors' duties that apply. And that can be difficult for directors living and working in Hong Kong who are from Hong Kong, who then have to consult people like me, foreign lawyers, on what their obligations are under the foreign laws of which they have chosen to incorporate a company and become a director. And there are some very, very interesting recent developments in English law that all of us offshore lawyers, BVI, Cayman, Bermuda, believe will be adopted in the offshore jurisdictions as well. So just as a reminder, English law is not binding strictly on these small islands of the BVI, Cayman, and Bermuda. Rather, it's persuasive. But when you have, the Court of Appeal in England or the Supreme Court in England, some of the finest legal minds in the world, the common law world, determining cases, then I'm sure, as probably in India, people certainly do take note. And I just wanted, therefore, to discuss what directors' duties are and some very recent developments that are going to affect directors here in Hong Kong. And the case is called BTI and Sakana. And that was a case before the English Court of Appeal, and in particular, a very famous insolvency Justice of Appeal called Lord Justice David Richards, and he's well known to the international insolvency community because he's very generous in giving his time to attending very prestigious conferences, the Insol conference, for example. He's a regular speaker and attendee, and as part of that, there is a judicial colloquium where judges like him and then judges from the other common law jurisdictions, Hong Kong, Singapore, the BVI, Cayman, Bermuda, and the United States, all get together privately to discuss developments in the law. So we couldn't have a better expert giving a judgment in this case. And essentially, the case was a very interesting situation where the directors of a company called Sakana had to decide whether they could declare and pay dividends to their shareholders. And the dividends had been paid at a time where the company had ceased to trade, but it had one material liability left. And through a complex series of corporate transactions, the company had these liabilities in respect of cleanup costs, damages claims, in other words, resulting from river pollution in the United States. So the directors made an assessment. They provisioned that the costs of the damages claim, the pollution cleanup in the US, would be X amount, and therefore they thought they had enough money to pay the shareholders of the company its dividend without causing the company to be insolvent or without any difficulty. And that was essentially the debate, the dispute in the case. And I should point out, the case has actually gone to the Supreme Court, the highest court in the United Kingdom. It's been heard, but we're still awaiting judgment. So the very latest, and I just double-checked before this talk, the very latest is this Court of Appeal case. And the question was, when does a director owe its duties to the creditors of a company? And what exactly is that duty? And when does that duty begin? So let's just go back a step. if you are in the laws that we deal with in Hong Kong, the offshore law, if you're advising a director of a company, you say normally, director, you must act in the best interests of the company. And the company is, of course, the general body of shareholders. And your duties are twofold. They are fiduciary, so that's super duty, if you like, of honesty, good faith, loyalty, and no diversion of corporate opportunity. You must be 100% loyal. And the second part of your duties is the duty in the law of negligence. So you must perform your duties as a director to the standard expected of a professional director of a company at the time. And those are the duties of skill, care, and diligence. And you owe those duties to your shareholders and no one else. However, if the company is insolvent, then of course you need to look at the reality of who has an economic interest in the company. So a company that is solvent, if you were to wind it up and liquidate its assets, you would obviously declare the company solvent, the creditors had been paid, and there is a surplus left over for the shareholders, and you would pay the dividend to shareholders before dissolving the company. In an insolvent company, of course, you don't have enough money to pay all of your creditors. Your creditors are going to have to be paid cents on the dollar or pence on the pound. They will not get a full recovery of the debts you will owe. And they, of course, take priority. They come before any shareholders. So after they're paid, there is no money left over for the shareholders, I'm generalizing, in an insolvent company. And that is what I mean by the economic outcome of the distribution of a company's assets. So when a company is solvent, of course, the economic interest is in the shareholders. When it's insolvent, of course, there's no economic interest in the outcome of the distribution of the assets because the creditors will be paid first. Now, who do the directors owe a duty to in an insolvent company? And forgive me if this is too obvious for some of the very skilled practitioners on this course, but of course the directors owe, it has been established since about 1988 in the common law world, the directors owe a duty to the creditors in an insolvent company. And just careful with that, it doesn't mean they owe the duties directly. Creditors can't sue directors to say, you owe me a fiduciary duty to look after me, you're my director. No, that's only for shareholders. But rather they owe a duty to the company to ensure that the creditors are considered very carefully. So another way of putting it from the case law is that the creditor's rights intrude upon excuse me, upon the company and step into the shoes, if you like, or displace the shareholders. The question in this case was, had the directors accurately provisioned for the particular liability they had, or had they been in breach of their duties and actually caused the company to, I use the colloquial language, to mistreat the creditors, to prejudice the creditors. So in the end, the creditors were found, sorry, the directors were found to have acted properly because they adequately provisioned on a reasonable basis, and they took into account as best they could what the liability would be before making the dividend. But interestingly, the question then became, well, what is the test? We know that directors owe duties to creditors in an insolvent company, but the case law suggests many possible answers as to the question of when the duty stops, when is it triggered? And there were four possibilities that the Court of Appeal in England looked at, which we're very confident will apply in Hong Kong and the BVI, Cayman, Bermuda. This case will likely be followed. Number one is the director's duties only apply when the company is actually insolvent, either cash flow or balance sheet. Now, that simply cannot be right, because a director cannot surely wait until the company is definitely formally insolvent before actually thinking about creditors. Because you can see from a cash flow basis, you can see what money will be owed when a company is going to be in difficulty, and therefore when you're prejudicing creditors. So that just must be wrong. The second then alternative was, well, are the directors liable when the company is on the verge of insolvency or nearing or approaching insolvency? And the difficulty with that was that the Court of Appeal thought that was too uncertain. It can lead to inconsistent results. The precise moment when a company is insolvent is difficult to pinpoint. Sometimes it happens suddenly, sometimes it happens over a period of time, and there's no time test or temporal test, as it were, to determine when the insolvency actually takes place. So on the verge of insolvency is just too imprecise. The third test then was, should the directors have a duty to the creditors when the company is or likely to become insolvent, i.e. of dubious solvency? And the Court of Appeal liked that approach a lot because it basically made the directors have a duty when they considered that it was likely, it was probable that the company was going to become insolvent. And on that basis, a reasonable director would say, yes, we absolutely have to consider the needs of creditors here. So you don't have to wait for insolvency. It's not imprecise on the verge of insolvency. You really are very likely, or sorry, just likely probable to be insolvent. But the case turned on actually a fourth formulation where the aggrieved party, BTI, who were the creditors, said, actually, it's a lower test. The test should hit the directors at an earlier stage. A lower test should apply to them. And the test should simply be when there is a real, as opposed to remote or fanciful risk of insolvency. When there's a real risk of insolvency, creditors must be considered by the directors. And the Court of Appeal just didn't like that because they said that is a lower test to probably becoming insolvent. It's too low a standard, and the directors cannot, in this particular situation, cannot possibly be held liable when they've correctly provisioned, they've looked at the potential liability for cleaning up the river and its pollution, and they've taken actually, they've made a good assessment that the company won't be insolvent. So just simply to say that there's a real, as opposed to remote risk of insolvency is just far too low. It would hinder and stop business activity, because as a director you could never take a judgment call, you could never take any risk at all in terms of business risk, just in case you're unable to pay a creditor. It's far too low a test. So this will be big work for all of us, because directors are absolutely coming to us right now. I mean, we might be a little bit ahead of you in India in terms of here in Hong Kong, in terms of the timing of insolvencies, because we've been suffering from COVID-19 for possibly a few months longer, dare I say it. And so we already have many inquiries by directors asking what they should do. Are they insolvent? Are they on the verge of insolvency? Are they likely to become insolvent? What do they need to do about the creditors? And then going back to cash flow, what measures can they take? So that is the landscape, if you like, the number one part of my talk, the government efforts to increase liquidity in the market, dealing with the cash flow situation, depending on what the recovery will be. And secondly, directors' duties in performing their obligations in this awful time in our economic history. So I hope that has been helpful and informative. And I, of course, will take any questions that people have. If I can answer them, I'll be delighted to try.
Hello.
Hello, I can hear you.
This is Ajanta Gupta. I want to ask, can you show some light on application of Gibbs rule in Hong Kong insolvency law?
Yes, I can, and that's an extremely difficult. It's an extremely difficult question, and it shows the sophistication of the audience that I'm dealing with here. Just to step back a moment, the Gibbs rule was a rule determined in the 19th century in England, and essentially the rule says that a debt cannot be extinguished, cannot be cancelled by a foreign court. So in the original case of Gibbs in the 19th century, it was a case where a French court was trying to extinguish an English law governed loan. And the English court said, you French courts can't do that. It's an English governed loan. If anyone's going to change, amend, extinguish, or compromise an English law governed debt, it will be the English courts. And that is how many English common law countries deal with the situation, and Hong Kong is no different, so the Gibbs rule applies. Now, interestingly, there are some countries who say that is a very silly and old-fashioned rule. Singapore is a country like that, and the United States is a country like that. And they say, well, if you're a company and you're in dire straits financially, and you want to restructure your debts, and you're an international company with many different loans governed by many different laws, if you turn up to the Singapore courts and seek a restructuring through a scheme of arrangement, and we happen to have to restructure, extinguish, or compromise foreign laws, why shouldn't we do that? This is the center of main interest of the company, and as a creditor will expect an international company to be seeking some relief in international courts where those courts have the power to amend and compromise debt, even though the law is not the law of Singapore. So there is a great debate in the world as to whether Gibbs applies. I can confirm, although I'm not a Hong Kong lawyer, I keep pointing out I'm a BVI and Cayman lawyer. In Hong Kong, when we work with Hong Kong lawyers very regularly and use the Hong Kong courts for our international restructurings, I can confirm the Gibbs rule does still apply here. And I think the rationale is thought that it's simply too dangerous to allow the world's courts to amend and extinguish contracts, because counterparties, the lender and the borrower, choose a certain law because they think it's dependable and reliable. And if a Hong Kong bank or lender is only willing to lend money to a company on the basis that good Hong Kong law is the governing law, the bank would say, then it would not expect the documents to be amended or the debt to be extinguished or changed by a foreign court. Only the Hong Kong court should be able to do that under Hong Kong law. And it might lead to what's called forum shopping. So let's imagine there was an unethical company out there who simply chose to go to a country where foreign debt can be extinguished contrary to the Gibbs rule. They might look for courts that were more debtor friendly, that were more willing to erase debts that were owed, and banks, of course, are very suspicious of those sorts of moves. So it's a complex, very, very good question, a complex question, but Gibbs is still, the old-fashioned rule of Gibbs is still alive and well in Hong Kong. That's been reaffirmed many times, with some minor exceptions to do with multinational schemes of arrangement, where the courts of New York in particular would have no problem with the variation of New York law debt in Hong Kong. It's quite a technical exception, which I've dealt with many times, but just to be complete so no one criticizes me for not giving them all the caveats and, and provisos there. So I hope that answered your excellent question.
Yes, sir. Thank you so much.
Well, no, my pleasure. And there's another question I just have on screen here, another extremely difficult question. It says, this is from Ravi Rajagopalan, and Ravi says, can you contrast the UK insolvency law provisions relating to wrongful trading, so for example, section 214 of the 1986 Insolvency Act, as against the common law fiduciary duties of directors owed to creditors? For example, would the common law obligation still prevail even if section 214 was suspended? Now, I must say that I am absolutely not an English lawyer anymore. I haven't practiced English law since 2008. I'm no expert, but having just read this very interesting case, as I said, of BTA Sakana, Lord Justice David Richards is actually very clear, because he does describe the interaction between the legislation, the 2006 Companies Act in England and the 1986 Insolvency Act in England. And he does actually say that the common law supplants and adds to that legislation, because the legislation expressly says in England that the common law still applies. So, for example, in this particular case of BTI in Sakana, there was no statutory test for when the director's duties applied to creditors, even though there were statutory duties set out in the legislation. So to try my best to answer the exact question of Ravi's here, wrongful trading under Section 214 is essentially continuing to trade when the company is insolvent. And so in those circumstances, there are obviously English cases that indicate when a director should know that the company is likely to become insolvent, and when he or she should not trade. So the common law will add to and complement, explain Section 214, and in fact those fiduciary and duties in negligence will inform the lens of refraction, if you like, that one must look through, the spectacles one must put on one's nose to examine if the director could be guilty of that wrongful trading at the time. So I hope that answers the question. If Section 214 is suspended by the UK government, then I would. I'm a mere lawyer, so what would I know? But I would expect that all of the case law that attaches to it would also fall away and not be effective. I'm getting a very nice thank you from Ravi on the text message. Well, thank you very much. There's another very interesting observation from Krishna Bhattacharya, who says, very witty, to solve the cash flow problem, government could just print more money. But of course, this would lead to inflation. Do you think that inflation could be a possibility for economic revival for the time being? Wow, Krishna, that I must confess, even a talker like me has to be humble and say that is beyond my expertise in terms of macroeconomics, and I open that up to the floor to greater intellects than mine to maybe comment on it. Okay, well, there don't appear to be any further questions. I just wanted again I'm really truly honoured to have participated in this. I hope I've given you some small benefits that will be useful to you in your careers. And Dr. Shikha, I wonder, should I hand back over to you?
Thank you, Anne. I assume that the audience has no more questions now? No further questions? Then we can end this Friday webinar series. I really have to thank you for taking out your time. And we have our GIP students also. We have some very great friends of our course and institute here. Okay, there's one more question, Anne. There's one question in the dialog box.
Now Naman has come in with a final last-minute question, which is a very, very contentious one. I'll just read it out. I know people can see it on the screens, but it's helpful to read out for anyone who's on a phone. What are your thoughts on suspending insolvency provisions? Shouldn't insolvency law be used more proactively in these times to allow companies to restructure their debt by taking interim finance during these times, or debtor in possession financing possibly in the future, says Vijay Sakar. I think this is a problem. I really am concerned, and this is just my view, but I am concerned about the many countries who have adopted measures that essentially suspend the normal working effects of insolvency laws. So, for example, many countries, Australia and England, have suspended wrongful trading duties for directors, statutory demands instead of, I think in Australia, again, I'm no expert, statutory demands instead of being 21 days have been extended to 6 months, I think, in Australia. There are measures in England coming into force, I believe, that will make it extremely difficult for landlords to enforce the obligations due under the lease, and foreclosure, and certainly taking possession of the home will be essentially impossible under the moratorium. Now, let's suppose that there is a universal global moratorium essentially on all material significant global finance. That would be devastating, because there would be no efficiency in the economy, and failing businesses would be allowed to continue, and those failing businesses are businesses that will cause future economic harm to creditors, to innocent people who expect insolvency laws to protect them. And directors will not be under a personal liability to think as carefully as they did, because the application of wrongful trading will not be there. It will also, just talking about us professionals, be terrible for us professionals, because it means that in times of economic crisis and insolvency, instead of relying upon nearly 300 years of developed insolvency law, restructuring, liquidations, and all the rest of it, instead all of those laws will simply be paused, and we won't be called upon to advise or assist anymore, because everyone will say, well, haven't you heard of COVID-19? Why should I pay you? I'm just not paying. And everyone will do that, and there will be a cycle globally, economically, where no one pays anyone for anything. And if that subsists, and maybe I'm exaggerating, how do you ever change the business mindset to require businesses to respect contracts, to respect the law of obligations and the performance of obligations? It becomes lawless, actually. So I'm concerned about it. I really am. I can see where certain measures for deprived persons, particularly socioeconomically marginalized people, should be protected. The very poorest, for example, homes and children and that sort of thing. But I think we have to be careful with it. It's definitely a balance. I see another question from Dr. Shikhar, and she says, well, listen, in that case, Ian, how do you motivate the directors, particularly the non-executive ones, to take up the challenge of leading the companies in these difficult times, to like this, and not to take an exit route rather than facing difficult decisions? Well, I have to say, I've spent the last probably 3 weeks being in and out of our conference with various directors of companies with essentially operations in China, and some of them are executive directors, some are what we call INEDs, independent non-executive directors, some are Westerners, and some are Chinese, and they are all faced with the same difficulty, which is they are very, very concerned about the cessation of economic activity. If, and we don't have it in Hong Kong, we don't have wrongful trading actually as a law under Hong Kong law, but of course it does apply under the BVI, Cayman, Bermuda laws. If those directors don't have the stick of personal liability, then of course I agree with you, Niti, that they're not going to be motivated in the same way. But before you even get there, my advice to the directors is always, maybe going back to the adage that our mothers used to tell us, that a problem shared is a problem solved. And very often the directors who are powerful, experienced directors running great empires actually feel quite vulnerable and scared at the moment. And when they come to us, we hold their hand a little bit. We have a pastoral and welfare role to say to them, listen, you may be worried about your personal liabilities. That's one thing. Actually, most of them are more worried about their reputation, about the company, about their employees and their employees' welfare and the future. And the only way to resolve that is by having open dialogue and communications with all of your creditors and stakeholders to solve the cash flow situation. They have to, I keep saying to them, they have to get aggressive about being communicative and sitting there and burying their head in the sand and hoping that COVID-19 will end soon and demand for their products will come back soon, so that the cash flow hole can be filled is not a good way to deal with it. I should actually say that a number of directors simply have never experienced this type of economic recession. So some of them were not particularly hard hit in the last recession in 2008, because in 2008 it was, China was still booming actually, and so for some of them it's the first time that they've ever had to deal with these sorts of issues. So it's very new to them. I see that Jane Pauline has come in with a wonderful comment. Currently, she says, India has not suspended wrongful trading provisions in its insolvency statute as a result of COVID, and has only suspended provisions to initiate insolvency. Would the attempt of directors to obtain loans and consequently securitize assets to obtain financing attract wrongful trading provisions when the suspension to initiate insolvency proceedings are lifted in India and the company is subject to insolvency? What a dilemma. What a predicament. I don't know is the answer. One would have thought that those duties would still exist for wrongful trading. Maybe you know better than me, Jane Pauline. Maybe you've given it more thought. I have to say I haven't given it much thought, because we haven't had the suspension of those duties either in our jurisdictions. But I would have thought that those duties still apply, even though pragmatically your creditors can't take enforcement action. Because don't forget, the filing of a petition, the serving of a stat demand, the liquidation of a company are enforcement steps. Intellectually, the company, if insolvent, is insolvent, and that is why you have this rule called the relation back rule. I don't know if it applies in India, but certainly in the jurisdictions where I operate, when a company is wound up, the courts say, yes, I wind up this company, I appoint a liquidator, but the effective date of this company being insolvent is the date when the petition was actually filed, and that might be 3 months prior. That's called the relation back period. And so all the insolvency laws about wrongful trading, unfair preferences, giving away assets at undervalue, all those sorts of things start as early as the presentation of the petition. So I always say to people, the petition is an enforcement. It's not an intellectual status, not an intellectual comment on the status of the insolvency of a company. So that's how I would look at it. But again, I must say, Jane Pauline, thank you for your question, but I certainly haven't given it much thought. It's an excellent question, and one that you will have to grapple with in India. I look forward to the Supreme Court judgment in India, where Jane Pauline is the lead advocate there. So very, very, very interesting. You're most welcome.
So I see there are no further questions. Thank you again, Jan.
Thank you.
You had a wonderful session. I personally had a lot to learn, and I'm sure all our viewers, they echo the same feeling. Just for the viewers, this video will be available on our YouTube channel. You tune in and watch it anytime. And we also encourage you to write to us any further question that you may have, and we can always lead it back to the speaker. And we can have more engagements. Thank you, Urvashi. Urvashi is a senior research fellow with the center, and it is basically her initiative that we started this Friday series, and our wonderful students and guests who joined us today. Do join us next Friday. Thank you.
Thank you, yeah. Such a informative session. Bye-bye.
Thank you very much, everyone. Stay safe.
Yeah, you too. Bye-bye.
Bye.